Hi everyone, this is Kalia from Marcus Evans. Thank you so much for joining us today on this webinar on the No Surprises Act, a cost-saving opportunity for employer plan sponsors. This is brought to you in partnership with Whole Benefits Law. But before we begin, I'd like to cover just a few housekeeping items. As you can see at the bottom of your screen are multiple application widgets. They're resizable and movable, so you can move them around to get the most out of your desktop space. I'd also like to encourage you to submit any questions that you might have by using the Q&A widget, which is located on your screen, and we will try to answer as many questions as possible. However, if a full answer is needed or we perhaps run out of time, we'll make sure to send you an email after the webinar. Also like to draw your attention to the resource list that will contain today's slide deck and bookmark any links that you might find useful. To answer any common technical issues, I advise to use the help widget. And finally, a reminder to look out for an email within the next 2 hours with links to view today's session. At this point, I'd like to introduce you to our moderator and our host. We have with us Mr. David Hall, who is the Chief Marketing Officer at Whole Benefits Law. We're very happy to have you on today, David, and I'm going to hand things over to you now.
Thanks so much, Kyle, and thanks to the team at Marcus Evans for helping us to curate this event. And I hope my title is not misleading to the audience. This is not a marketing event. This is a thought leadership opportunity for everyone who's here. And so I'm just here to help moderate the session, to ask some questions of these two thought leaders. And with that, let's meet our speakers. It gives me great pleasure to introduce both Jeremy Kilburn and Ann Tyler Hall. Jeremy is the Chief Legal and Compliance Officer with Wayne Sanderson Farms, someone that we here at HBL have gotten to know over the last year or so. And he provides strategic counsel and guidance across an array of variable critical issues affecting the growth and success of that company, Wayne Sanderson Farms, and its business partners. He was also keenly involved in a relatively recent merger, which included development of strategy, public relations, governmental relations, and negotiations with regulatory agencies. And I think you'll really enjoy hearing from Jeremy and his thoughts on this very cutting-edge topic. Our other speaker, the other person involved in this dialogue today is Ann Tyler Hall. She is the managing partner, and she's also the founder at Whole Benefits Law, or HBL. HBL is a boutique ERISA and employment law firm recognized in 2021 as an Inc. 5000 fastest growing company in the United States. And we're very proud of the fact that we've successfully avoided and abated $75 million in ERISA compliance penalties for our business clients over the last 3 or 4 years. Prior to forming the firm, Ann Tyler Hall was a practicing ERISA attorney, as she is now, but with both Alston and Bird and King and Spalding, two of the largest law firms here in Atlanta. And so, again, it gives me great pleasure to introduce each of you to Ann Tyler Hall as well. So as an introduction to the topic today, we are going to be looking at some outcomes and some opportunities. And so to kick things off, I'll just give you a broad overview that in 2021, at the very end of 2021, there was legislation passed, and effective January 1st of 2022, the No Surprises Act provides an employer plan sponsor of an ERISA group health plan, of which I think we have many on this particular call, an opportunity to revisit the plan's administrative services agreements with third-party administrators and to reduce or eliminate certain fees that are being charged by that third-party administrator. Indeed, because these potential savings can be significant, sponsors have a fiduciary obligation under ERISA to understand these fees and how they can be reduced in light of that act. And so I'm excited to share with you that after our presentation today, we will be sharing additional thought leadership from our legal team that takes this presentation one step further. We will be talking in that article about PBMs and how do we hold PBMs' feet to the fire. But today's topic is TPAs and fully insured plans. And so I'm very interested to learn, before we jump into the dialogue, the status of you, the audience. Your company's primary health and welfare plan Can you please tell me if it's a self-insured plan, if it's a fully insured plan, or as a company that you do not offer a health insurance plan as an employee benefit? And if you are on the call today and you're not a chief legal officer or a VP of HR and you're a participant in a plan and you know the status of your company's health plan, we welcome your participation in this particular poll. Okay, let's take a look here. Okay, so over half of our audience has a self-insured plan. The other third or so looks like fully insured, and then we have a few people who do not currently offer a plan. And those of you who are thinking about becoming fully insured or putting a plan in place, this should be very informative to you as well, even if you're not a self-insured plan now. So let's get the conversation started. Again, we've got two thought leaders here. This is a great opportunity for some peer learning. So Ann Tyler and Jeremy, what historically speaking has been the relationship between insurance carrier or these large insurers, the carriers, if you will, third-party administrators, which we refer to affectionately as TPAs, and PBMs, pharmacy benefit managers, and what opportunities have existed previously for plan sponsors when discussing contract terms with these service providers?
Thanks, David. So I'll jump in and talk about history, past, present, and what might be coming down the pike. We have seen over the past few years a very active legislative period impacting health and welfare benefit plans, retirement plans as well, but health and welfare benefit plans. And part of this discussion and Congress's involvement has been because Congress has asked the question, because their constituents, business owners, plan participants are asking the question, why is healthcare so expensive and increasing in cost exponentially every year? And so Congress it's a bipartisan issue to understand the costs related to healthcare. And the third-party administrators, the insurers, and the pharmacy benefit managers all work within an ecosystem. And this all came out even recently. There have been hearings over the past few months really drilling in on pharmacy benefit managers because their fees are so non-transparent. There's been obfuscation of rebates, spread pricing, all of the fees that are coming to the PBMs, the top three PBMs who own 80% of the market posted more than $10 billion in profits last year. $10 billion, not revenue, profit. This is CVS, Caremark, Optum Rx, and Express Scripts. Third-party administrators as well, some of the top insurers, TPAs, two in particular in the top 10 posted $8 and $10 billion respectively in profits. And so Congress has had interest in the fees and the costs associated with these service provider relationships. And it has not been an easy task, even for Congress, to understand all the fees, all the costs and payments that go to the insurer, the TPA, and PBMs. But what came out recently in the Senate hearings on looking at PBM costs specifically is that all of these service providers are working collectively, and there is a system in place. And so historically for plan sponsors, what does this mean? Well, plan sponsors are the client, and they have an agreement with each of these providers. What has happened is that for whatever reason, the service provider has really had the upper hand in these agreements, and there's been very little pushback from plan sponsors to negotiate these agreements. Arguably, there has been leverage for plan sponsors to negotiate better agreements, more favorable agreements historically over the last decade. But certainly now with the Consolidated Appropriations Act changes that implicated or that ushered in the No Surprises Act, with the transparency and coverage rules that were passed as part of the Affordable Care Act, with those changes and with these transparency rules, we see a unique legislative tailwinds to negotiate better, more favorable service provider agreements. And quite frankly, this is a fiduciary obligation. Most group health plans are ERISA plans. There's a fiduciary responsibility to pay no more than a reasonable cost for services. And so it's really important for plan sponsors not just to sign off on a service provider agreement, but to really understand and negotiate best-in-class provisions in the service provider agreement. And this has historically been an obligation. It's historically been an opportunity, but we're in a unique period now with the legislative tailwinds of transparency rules that have come out recently, the No Surprises Act, and then also the legislative landscape. And we're seeing more insurers and TPAs get sued for failure to provide claims data, failure to provide certain important data for plan sponsors to even evaluate clearly what they are paying these service providers.
Great. Ann Tyler, thank you for shedding some light on that. Jeremy, what has your experience been, historically speaking, again, not taking into consideration some of the things we'll talk about shortly, with these types of service provider contracts and agreements?
Yeah, thanks, David. Sort of echoing everything that Ann Tyler just said, but for us, I mean, we were a company with pre-merger with insuring roughly 10,000 lives. Now, as a combined company, we're close to 27,000. But even as large of a company as we were, and as good of a count you would think we would be for these third-party service providers, we still had a lot of difficulty in engaging in what I would call just fair and good faith bargaining over terms and conditions with them. The sort of the difference, or what really started to open our eyes, was I have the privilege of serving both with our Health and Welfare Benefits Committee as well as our Retirement Benefits Committee. And there really, over the past 5 to 6 years, has been a continuing divergence in terms of the level of, I guess, bargaining power or transparency that we get with those different programs. Obviously, with regulatory activity and plaintiffs bar activity on the retirement benefits side, third-party service providers have been forced to come to the table and meet halfway and provide the sort of transparency that that we need. But on the health and welfare benefit side, it is I've heard it described as an ecosystem. It's an ecosystem that we're not involved in. We're not a part of that ecosystem. We're sort of on the outside looking in. And some of the biggest issues you talked about, transparency. I mean, for us, it was understanding sort of what exactly are the services being provided. What are the fees that are being charged for those services? What relationship do those two things have? And there was almost zero ability for us to really review whether or not the contract we were in was a good deal. There were constant arguments during contracts and leading up to negotiations about ownership of data. Clearly, our position is, the data that those TPAs are utilizing, or that the PBMs are utilizing, is our data. It's our plan member data, and we should have full and unfettered access to that. But those requests were always met with roadblocks and just flat out refusals to provide us the information that we needed to not only evaluate the job that those service providers were doing, but giving us the information that we needed to even bid it out to another service provider to potentially make a change. And so, and we have, tried and been through a number of contract negotiation cycles over the years, where myself and other in-house counsel have sent back red lines of contracts to some of these providers, and inevitably, we're simply told, there's no negotiation. We can't make these changes. If we did it for you, we'd have to do it for everybody. And, that always, left us sort of, wondering, what other opportunities there might be. And again, we'll talk about it later, but what led us to sort of starting to work with Ann Tyler on helping us negotiate those agreements more effectively.
I think that's a great segue into our next question. And I want to just talk a little bit about regulation and enforcement. So, we're having this conversation about the rocky road that plan sponsors have been forced to travel when it comes to really even understanding the agreements that they're bound to, right? And so you have this legislative action. Why do you think now Congress and the courts are struggling so much to actually determine how to regulate these TPAs, how to regulate these PBMs, despite the fact that there are now laws on the books that basically describe how those organizations should be acting relative to plan sponsors? What is the glitch in the system?
It's a great question. So part of I think the problem is that this ecosystem has existed for many years and has only become more solidified. And so what we see in the agreements is it is impossible to truly understand how much you're paying the service provider through definitions, through obtuse agreement terms. We've seen definitions in PBM agreements where it would be impossible for a plan sponsor to truly understand what rebates should be coming back to the plan. That's unacceptable. And the TPAs, we saw a provision, we're negotiating a TPA agreement right now where one of the provisions, we were just discussing this with the plan sponsor yesterday, one of the provisions said 100% of the medical rebates through the TPA agreement come back to the TPA. Why? And what does that mean? And those are the types of provisions that are, it's hard to not believe are intentionally obtuse to deflect what's actually being paid to the service provider. But we know it is being paid because we know what the profits of the TPAs and the PBMs are, and they continue to increase exponentially year over year. And so part of it is understanding some of these backdoor arrangements, some of these backdoor terms and provisions, and Congress is making some attempt at that. The service providers involved, as we might imagine, have powerful, influential lobbyists. But at the end of the day, I think healthcare across the U.S. has become has continued to increase beyond even inflation. It's been soaring, and so there is, again, a tailwind, a unique, I think, tailwind legislatively to really dig into why healthcare is costing so much and what each of these service providers are charging, and are they adhering to the terms of their agreement, or are these provisions made so obtuse that it's just impossible to truly understand what's being paid to the individual service providers?
Yeah, and I would just say, I think, in a traditional contractual sense, a third-party administrator, it should seem like a fairly straightforward arrangement where, I don't want to staff up and have people have a staff of 100 who are paying medical bills from the assets of my plan. So, I engage with a third-party administrator to essentially negotiate with hospitals and then pay those bills for my plan members on our behalf, with our funds. And unfortunately, the relationships and the contracts have gotten way more complicated than that. It's not just a simple function of pass-through billing. There are, as Ann Tyler said, there are there are rebates. These TPAs are serving a lot of different providers, including insurance companies, and some of them are owned or affiliated with insurance companies. And so it's difficult really to fully understand the role that they play in every market where they operate, and it's difficult to sort of quantify the value that they deliver to plans like us. So it's just, and I think that's why it's been hard to for Congress to really nail it down, is because you just you can't nail down precisely what it is that they're doing on behalf of our plan.
Great. Thank you guys for that. Okay, let's move on to number 3, our third question. And Jeremy, I'm going to kick this one off with you. We've talked a little bit about, excuse me, I hit the wrong button. There we go. We've talked a little bit about history. We've talked a little bit about regulation and enforcement and what makes these things difficult. Let's talk a little bit about the current reality for plan sponsors. And obviously we're here because we have what we believe is a real opportunity for proactive plan sponsors. So Jeremy, as a proactive plan sponsor, what has been your experience actually going through the negotiation process, alongside HBL, if you will, and what sort of pushback did you feel from the TPA? Were they willing to come from the table? Could you just give me a sense of your experience as the chief legal officer at a company like Wayne Sanderson Farms, who's kind of thrust into this opportunity, but also going to receive pushback?
No, and I think, I referenced earlier historically that there was a lot of resistance from the TPAs and the PBMs around negotiating key terms, whether it was indemnity or, including provisions in the agreement to ensure that they had fiduciary obligations to our plan members, issues over data ownership. There were always a lot of sort of hot button issues that we tried to push back on, and we're just unfortunately rarely, if ever, successful in getting language that protected our company, protected our committee members, and delivered any savings to our plan members. And with this new paradigm, with the No Surprises Act, I think it created a window and created certainly an opportunity for us and to engage outside counsel to start to leverage that, as well as leverage some of the other laws that have been, the Consolidated Appropriations Act, et cetera, provided us an opportunity to start to get some better terms and yield some real savings in real dollars. And we're for a plan of our size, we're hoping to yield, 7 figures type savings once we get through with our process when the two plans are consolidated. And I think, that's an important thing for our plan members, but for the company, I think more importantly is protection from third-party suits, and making sure that we as a committee are doing our job in really pushing these guys as hard as we can to basically comply with the law. And through our partnership with Hall Benefits, we've been able to, I think, yield a lot of, in addition to the financial savings, we've gotten very favorable terms with a number of providers. Those very same sort of terms that were rejected outright in years past. So I think there is a window of opportunity here to protect your plan, to protect your committee members, to protect your fiduciaries through an aggressive negotiation strategy.
And Ann Tyler, from the perspective of an ERISA attorney, we talked about the ecosystem of PBMs, TPAs, and carriers earlier. It's funny you use that word. I often talk about the benefits provider ecosystem, where the plan sponsor is at the center, and you've got ERISA counsel, you have brokers, and you have other people who are providing valuable services to these plan sponsors in a much more direct and I would say transparent manner. And so tell me a little bit about the players involved on the service provider side when it comes to these negotiations, because I've heard more than one plan sponsor say, oh, our broker handles that for us. And by the way, we have wonderful relationships with brokers. We really respect what they do and how hard they work for the plan sponsor clients that they have. That being said, when a plan sponsor says my broker can do that for me, some red flags go up at HBL. And Tyler, can you talk a little bit about that ecosystem, where ERISA Council fits in, and where maybe brokers and other service providers would fit into this process?
Great question. We get asked it a lot. We work in tandem. It is best, this strategy is done best working in tandem with the plan sponsor and the broker. And to Jeremy's point, I do want to acknowledge what Jeremy has said. These negotiations have not come easily or without pushback. And we've been on calls with large providers where they have 3 of their in-house counsel on the call, carefully, scrutinizing every one of our changes. And again, this is why you need outside counsel to go in and negotiate. And sometimes this negotiation takes a few months of a back and forth and a pushing. And what we have found in our discussions with brokers is they don't have the resources in-house to go in and negotiate and the expertise of working through these provisions day in and day out. They can't do it for each and every one of their clients. But we have never been involved in a negotiation that did not result in significant money back to the plan. And these are annual savings. I think for 2022, we realized about $5.5 million total back to our plan sponsor clients from these.
And that's going to repeat itself year after year. Is that correct?
And year over year, which is exciting for us. We want plan sponsors not just to fulfill their fiduciary obligation. That's important, and that's part of the importance of this TPA agreement. But it's wonderful to see some of that money coming back to the plan. We look at these profits of the insurers, of the PBMs. We understand they're in business, but some of that money should be coming back to the plan, and we want to go facilitate getting that back. But the brokers have made it clear to us, and certain brokers specifically have pulled HBL in to be their resource to go in and negotiate these agreements for their plan sponsor clients, because they can't do it for each and every one of their clients. But I think while we have some legislative tailwinds, it really, the onus is still on the plan sponsor to go in and negotiate these agreements. And some of the pushback that we've gotten on certain terms, we leverage that relationship, and most of the clients that we've been working with, even smaller clients, these are multi-million-dollar a year contracts that these service providers don't want to lose. And so plan sponsors have to understand that they do have negotiating power, and the legislative and litigation tailwinds are helpful, but these service provider agreements should be a standard operating practice. It really is now a fundamental part of fulfillment of ERISA fiduciary responsibility of the plan sponsor. And ERISA states, if you don't have the expertise in-house to go and negotiate these terms and fully understand what's being paid, go out and that won't hold up in court. You need to go out and hire the outside expertise. And so, again, this is a dual fulfillment. It's mitigation of ERISA fiduciary exposure. We've certainly seen it on the retirement plan side. Top 10 ERISA settlements, most involving fiduciary breach, most involving that the plan sponsor paid unreasonable fees. Top 10 ERISA settlements over the last 3 years, $1.6 billion that plan sponsors had to pay out. Hopefully they had fiduciary liability insurance. We don't ever want a plan sponsor in that situation. So it's mitigation of exposure. And so, our response to the TPA is, this is a plan sponsor's obligation to negotiate this contract. And if you're not willing to have this discussion, then, we're going to have to give plan sponsor our honest assessment that that is interfering with their fulfillment of fiduciary responsibility to negotiate the terms of these agreements. But we've seen it certainly on the retirement plan side, and it's starting to, I think, bleed over into the health plan side, because again, the costs are so high.
Okay.
I'm just follow up that, this is becoming historically, benefit plans committees, you're looking at plan structure and the level of benefits and benefit cost, but this really is becoming sort of another key focus of our committee and of my team, to ensure that we are really looking at these agreements and looking at our obligations through the correct lens here, and really with as high of a level of scrutiny that we have, again, traditionally applied to our retirement plans.
So we're getting some really great questions in, guys. Jamie, it's great to have you on today. And I'm going to go ahead and just pose this question quickly before our second poll question of the day. Jamie asks, or she states, I believe accurately, that brokers have a conflict of interest, and so do the TPAs. How do we, and I'm assuming Jamie means those of us who are out there trying to help plan sponsors better understand the opportunity, how do we get plan sponsors to understand that this is a conflicted market? And Tyler, I'll let you take a quick shot at that, because we do need to keep moving, but I do think this is a very related question.
It's a point that we walk gently around, and it is incumbent upon us as ERISA attorneys, outside ERISA counsel, to explain to our clients what's at stake. And so Jamie raises a great point. Again, it's why it's so important to have outside, non-conflicted counsel. Our primary focus in negotiation is to get the best-in-class agreement for a plan sponsor client, and it works if we apply the leverage. So our position has always been broker. We're not working in opposition. We're working in tandem. Work with us. And help us leverage. Brokers often place significant books of business with certain TPAs. So help us, get on these calls with us and help us leverage the fact that a TPA is willing or not willing to negotiate more reasonable terms in these agreements. So our position, Jamie, has been, let's work together. But you raise a great point. That it's a point that we've talked about internally. Brokers don't have the resources in-house, and then arguably there's a conflict. I mean, they've placed some of this business. They've pulled in the TPAs for the RFP. And so it's a really awkward, delicate situation for them to then be negotiating terms of that TPA agreement. Why it's so important to have an outside third party to come in and we were reviewing these provisions and agreements on a daily basis, so we know what's standard, we know what's reasonable.
Good. Gilbert, Ricardo, Christina, we see you. These are great questions, and I think we'll have time to get to these at the end. Let's make the jump here to our second poll question. And how about that? It fits right into our conversation. How involved is your organization in securing favorable contract terms with your health plan TPA, assuming you have a self-funded plan? If not, this may be one you can sit on the sidelines for. But there's a spectrum on which you probably fall somewhere. Do you utilize ERISA counsel for complex benefits contract negotiations? Are you trusting your broker consultant or your broker or consultant to secure the best contract terms with your TPA? Or C, don't recommend, sign the renewal paperwork and don't ask any questions. We'll give you guys just a few more seconds to think about how you approach securing favorable contract terms. And the poll is populating. We've got about another 10 seconds or so. This is an important question to ask yourself, and maybe some homework for those of you who answer question answer C, maybe to go back to the drawing board. Okay, let's see here. Okay. So a little less than half of us are utilizing ERISA counsel. Just over half are trusting our broker or consultant to secure the best contract terms. And you shameless 5%, sign the paperwork and don't ask any questions. Okay. A used car salesman's dream. Okay. Question number 4. Let's talk about the F word. So from a fiduciary perspective, could you please describe some of the risk facing plan sponsors if they move forward with quote unquote business as usual? And Tyler, if you could jump in first, and then Jeremy, I recall we were talking about this ahead of the session. You had some really great things to expound on after Ann Tyler. So from a fiduciary perspective, Ann Tyler, talk about some of the risks.
Yeah, so I alluded to this earlier. We've seen large, and even in the nonprofit space, we've seen large plan sponsors get hit with fiduciary breach lawsuits because they weren't, arguably, according to plaintiffs' attorneys, carefully monitoring plan expenses, ERISA plan expenses. And the plaintiffs' firms have become very adept at finding gaps by plan sponsors. And part of that is failure to negotiate the service provider agreements, failure to really understand the fees that are being paid by the plan and negotiating those fees so that they are market. And so we've seen just a real uptick in fiduciary breach litigation. So there's significant exposure. I think I mentioned top 10 ERISA settlements, just the top 10 over the past 3 years, fiduciary breach lawsuits, most of those involving an allegation that the fiduciaries were not negotiating fair or paying reasonable expenses for the plan. 1.6 billion in ERISA settlements. And unfortunately, most of that isn't received by the participant. That goes out of the plan sponsor's pocket or out of their fiduciary liability insurance policy. And so we want to mitigate exposure to what is becoming an ever increasing significant area of exposure, fiduciary breach lawsuits and failure to properly monitor service provider payments and pay reasonable expenses.
Yeah, and I think and we've just gone through this, the application process for fiduciary coverage for your internal committee members and officers and decision makers who are involved in these processes. And if you don't have that sort of coverage, I would certainly encourage it. But going through that application process, you realize that, these are the type of questions that the underwriters who are, insuring these risks are looking at. What are you as a company doing? And what are you, as a benefits committee doing to ensure that your process that you're running in selection of the third party administrator, selection of those PBMs and any other service providers, that you're engaging in a fair selection process with transparency, and that you're really looking at the financial side of those relationships. Because if you're not doing those things and you can't get fiduciary risk coverage, then that's a pretty good indication you're not living up to the standards that the trial lawyers are going to impose on you in the event that they file suit against you on behalf of your plan members. But for us, it's we want to obviously protect the personal interests of all of our committee members. And that is one of the things too that we were able to negotiate with one of our service providers was some again additional sort of protection on their end for the decisions and representations and warranties for the decisions that we were making as committee members in selecting them and utilizing their services as well. So again, I encourage you to leverage your relationships with outside counsel who are experts in this area, because it's very hard, again, for a company to be staffed up, to have this level of expertise, and to go through these lengthy contracts and identify all of the potential risks that you and your peers may be facing by serving on committees and making decisions that you hope are in the best interest of your plan members.
And I would just piggyback off of that. So a fiduciary can be held personally liable for losses to the plan. Now, what we've seen is courts don't implicate that typically unless it's an egregious fiduciary breach, but it's still a risk. And it just highlights why it's so important to be carefully reviewing these agreements, negotiating these agreements. I imagine most, if not all of you participating today, you're an ERISA fiduciary. You have discretion over plan assets and administration. You're making important decisions. And so part of protection for yourself, for the plan, is careful review and negotiation of these agreements.
Good. And it strikes me, I don't want this to get lost because we're talking a lot about process and complex negotiations and fiduciary duty. There aren't that many opportunities for plan sponsors to make an investment that has tangible ROI, right? And so as we go into our final panel question, hopefully have some time here at the end to go into some of our attendee questions. I just want people to be thinking about the fact that when you choose to be proactive, as Wayne Sanderson Farms, as other clients of ours have been and have queued up to be a part of these negotiations, there is real tangible benefit in the form of United States dollars back to the plan, which can be used in other ways besides funding your TPA. So just again, I don't want to lose sight of the concrete results of these negotiations. We probably will get to that. But let's be mindful of time. We'll move on to panel question number 5. This is our final panel question. Beyond the money back and the risk reduction, are there any competitive advantages that might be provided by successful negotiations of the type we are discussing today? And as the plan sponsor, Jeremy, I'm going to ask you this question first. And what are your thoughts around competitive advantages? And maybe you could just tell us briefly what industry you're in to give people some context.
Yeah, we're a chicken company. If you eat at any of your fast food chicken restaurants, you may be eating our product, or we have, like I said, we have around 27,000 employees, roughly $9 billion a year in revenue. Most of those employees are hourly workforce. It's unfortunately a high turnover industry. It is labor intensive. I mean, we need roughly 1,000, at minimum 1,000 people at every one of our facilities to be able to operate. A lot of our facilities are in somewhat rural areas because you can't grow chickens in the city. So we really have to offer a competitive, not only wage, but benefits package to our employees, to really attract and maintain employees. It is having a great benefits package that's a low cost package. It's an employee retention tool. And we can, our HR team can put metrics around that and show that. And so, and it's not just the cost of the plan at the employee level, it's their overall experience. I have a hard time when I go to the doctor and get medical bills, sort of, I get those statements from our third-party administrator, and I have a hard time figuring out myself, what is it that I owe? What is my copay? Is this a bill? And so what we're looking to do is, the savings, monetary savings that we're leveraging, we're really trying to reinvest that in sort of, outreach tools, or going and pushing on our TPA. Hey, what resources can you help devote to help our workforce really truly have no surprises when they go to the doctor, as the act is entitled. That's really been our focus, is rather than just putting that money back into the bottom line of the company, we want to really reinvest it in not only sort of a better healthcare experience for our employees, but wellness initiatives to help sort of drive down cost. We've been able to sort of expand on-site health clinics and things like that, and to really get our employees to have a as close as that we can to really a concierge medical service. I mean, that's what we want, for the best price that we can get. So I think there is a competitive opportunity for recruitment and retention of employees, and really just giving our employees the best experience that they can have. And that includes, when they need to go to the doctor or take their kids to the doctor on our plan. So.
And Tyler, any additional thoughts there? Maybe some additional provisions that HBL might be able to, negotiate that could provide a competitive advantage in the marketplace?
Yeah, some of the provisions that we've negotiated in addition to money back, cost savings on the agreement through the agreement, the cost of the agreement. We've negotiated co-fiduciary status for the TPA. We incepted a negotiation last year where the agreement stated that the TPA was under no circumstances a fiduciary. They most certainly were a fiduciary and had fiduciary responsibilities. And when they performed fiduciary functions, they are a fiduciary. And we had it included in the agreement. Another provision that we negotiated is indemnification and standards for performance standards. One of the agreements that we negotiated stipulated that the TPA was not responsible for any loss to the plan unless the plan sponsor could prove gross negligence. It's almost impossible to prove. So we said, no, that's not market. And so we moved that up to a standard of negligence. And TPAs are handling a lot of claims and issues. And quite frankly, they mess up as service providers do. And when they do, they should be responsible for covering the costs of those mistakes. And so it's that again is cost and savings and mitigation of exposure to the plan sponsor. The other provisions that we've been able to negotiate is with the Consolidated Appropriations Act, a myriad of new compliance obligations for plan sponsors. One of those being mental health parity, non-quantitative treatment limits, comparative analyses. Now a plan sponsor has to provide that every year. Well, the TPA has critical information for completing that MAPIA comparative analysis review. And in our, we've done the review, the MAPIA review for a myriad of different clients. And part of our challenge has been getting the information we need from the TPA. So one of the agreements we negotiated, not only would the TPA provide the information, but they would provide the analysis and that we would then review it. And that's significant cost savings for our plan sponsor client, rather than us trying to wrangle with them to get that information. One of the provisions that we've been working on, and a large TPA insurer has been recently sued. We're still working on this, is claims data. And Jeremy mentioned it earlier. The TPAs and service providers are stonewalling on claims data being proprietary data, proprietary to the TPA, which is astounding. This is the plan sponsor's information, their claims for the health plan. And so we've been trying to push forward on negotiating in these agreements greater access to full access to claims data. So those are just a few of the other provisions. Some other provisions: cybersecurity, HIPAA compliance and protections. Again, these agreements from the onset are incredibly service provider friendly. They're drafted that way. And so there are a myriad of different other provisions that can and should be negotiated to provide for a more balanced and favorable paradigm for the plan sponsor, and as I mentioned, money back and mitigated risk to the plan sponsor.
Great. Ricardo asked the question earlier, what are examples of the types of things being negotiated that providers are reluctant to discuss? He mentioned discounts, rebate guarantees. length of termination, contract language, et cetera, or is it just data or all of the above? I think, Ricardo, we have our answer. It's all of the above. And a good ERISA team will go in and advocate for the plan sponsor in all of those areas, some of which will show monetary benefit back to the plan, and some of which will protect you as a fiduciary, some of which will allow you to keep your data and your data to remain your data. So I think it's all of the above. So Ricardo, thank you for your question. I'm going to just advance the slides so that we know we're approaching the end here, but we have some really good questions. And so one of them, let's see here, had to do with gag clauses. And I'm looking for that question because I know, Ann Tyler, that we have had conversations. Here we go. Christina asks or states, we're having a problem getting TPAs to confirm they're in compliance with the prohibition of gag clauses. As they say, they don't want to open up provider agreements before they sunset. Do you see this as well?
Christina, that's an excellent question and an excellent point. And I'll just say we just finished a negotiation where we stipulated in the TPA agreement that the TPA would annually attest that they had fulfilled their obligations on the prohibition on gag clauses. And to your point, so the TPA, you're having difficulty with them confirming compliance. Why? Why is that a problem? That's a transparency issue. And if there's nothing to hide in these disclosures, then why is an attestation and a commitment to prohibition on gag clauses a problem? It raises a red flag. We haven't had any pushback on the TPA agreements that we've negotiated. But to your point, Christina, we've explicitly included, that's one of the Consolidated Appropriations Act provisions, that we require the TPA to do the annual, this is an annual attestation on behalf of the TPA that they are fulfilling their obligations or that there are no gag clauses. They are fulfilling their obligations on the prohibition on gag clauses, which is another transparency requirement that was included in the Consolidated Appropriations Act, that you couldn't prevent disclosure of certain items, certain issues.
Good. And thank you for your question and for your statement, Christine. I think it brings to light additional facets of this conversation that we really, in an hour won't be able to get to everything. My next question, Jeremy, is for you. Just in general, if you'll just share with the group, how effective has the strategy of using ERISA counsel to help with these negotiations been for Wayne Sanderson Farms? And then, Ann Tyler, I know you've been boots on the ground along with your team in actually negotiating these, and you've been walking alongside the HBL team, Jeremy, as we've done this. In what areas did Wayne Sanderson Farms or where did HBL find the most opportunities for savings, or was it more intangible? If you could just speak a little bit to your experience, and I'm sure every plan sponsor's experience will be different depending on the contract they're in.
Well, I think it was tangible and intangible. And as I've said, we've realized some pretty significant savings that we're trying to find a way to return back to the plan in the most effective way. But I think the overall strategy, a lot of it is about just it's shifting risk. Trying to we're paying these providers literally millions of dollars a year. And really pushing back and trying to shift some of the liability risk back onto them, away from your plan. It's certainly worth the investment. There are other sort of ancillary benefits like the ownership of the data. Having no questions about that, it puts us in a position to be able to prepare a more effective sort of bid package if we wanted to switch from one TPA to another, because the switching cost is very high. And that's always been sort of the impediment before to really driving a hard negotiation was, it's a 3-year process to get to another service provider. But having ownership of the data and being able to, force them to send us a data feed gives us that ability to shop what they're doing. So it has been an effective strategy, but you have to be willing to, to tell the TPAs that, you'll go another direction. And I know there's not a ton of options, but you've got to be able to have that conversation. And we've had it, and it's been, and it's yielded positive results.
Good. And thank you, Jeremy. I appreciate you shedding some light on your experience at Wayne Sanderson Farms. And as a growing company, it just becomes more and more important as time goes on, as you grow, to make sure that we're doing all the things we've talked about today. We're getting very close to the end here. I'm going to hand things back over to Kyle shortly, but just one more question, and maybe Ann Tyler, you could lead the way on this one, because I know you do have your thumb on the pulse of what's going on in the ERISA and employee benefits world at large. Considering the legislative tailwinds that we've been discussing, considering the things that you and your team are talking about in your scholarly articles about PBM negotiations and TPA negotiations and cybersecurity and all of the myriad of things that are going on right now where opportunities are there for the taking for plan sponsors, do you foresee a future environment, Ann Tyler Hall, where service providers are coming to the table and rather than being bad actors, for a lack of a better term, are really trying to do things for the benefit of the plan sponsor across the board based on responsibilities outlined in the law? Or do you feel like this is going to continue to be an uphill battle for plan sponsors? Tough question.
Yeah. Part of this is just an entrenched paradigm that just becomes more and more entrenched. We talked about the ecosystem at the onset of the call of this of our discussion today. But while Congress has given plan sponsors some tools now, I mentioned tailwinds legislatively, it really, the responsibility does fall on the plan sponsor to get in and understand and negotiate these agreements, and fiduciary obligations have never been more extensive, but never been more important to fulfill on behalf of the plan and the participants in the plans. So I would say that I don't see service providers coming forward to shave off some of the profits and to give money back to the plan, and to provide more transparency voluntarily. But I do think that plan sponsors are in a unique position to negotiate more favorable terms and fulfill their responsibilities. And within that negotiation, understand the terms of the agreement better, understand the relationship better. One of the things that we see often, and this is often after a problem or a mistake has occurred, there's a real discrepancy in what the plan sponsor understands a service provider's responsibility or TPA's responsibility to be, or their obligations, and what the agreement, what the paradigm actually provides for or requires of them. So the negotiation process is an opportunity for the plan sponsor to fully understand the contours of the relationship. These are important relationships. These are multi-million-dollar contracts often for our plan sponsor clients. And you need to, as a plan sponsor, as a fiduciary of the plan, understand the contours of the arrangement and the relationship. So I think it's going to, I don't think anything is going to change dramatically with respect to it being incumbent upon plan sponsors to go and negotiate these agreements and call for a more favorable, marketable, reasonable agreement and relationship with the service provider. But I also think that the environment has never been better for leveraging as a plan sponsor the relationship with the service provider. What we find is, again, even smaller plans, we're negotiating a 2,000 employee member plan right now, and the service provider doesn't want to lose those contracts, and so we use leverage points to negotiate these provisions, we also talk about the No Surprises Act and the fact that Congress contemplated that that the costs related to out-of-network services after passage of the No Surprises Act should reduce TPA costs by as much as 85%. And it's hard for the TPA to argue with that. So again, it's important for plan sponsors to be engaged and to be proactive in this area, because while we do have transparency rules, we do have legislative tailwinds, it's going to be incumbent upon the plan sponsors to hold the service providers' feet to the fire. And I don't think we're going to see that paradigm change dramatically anytime soon.
Jeremy Kilburn and Tyler Hall, thank you so much for your thought leadership. Thank you for what you're doing to advance this conversation amongst your peers. Marcus Evans, we appreciate the platform. And if you registered for this virtual event, you will hear from HBL directly. We'll be sending you a copy of each of our most recent articles discussing these concepts. And I hope that you'll reach out directly to us if you've got any questions or we can help. Again, thank you both. I'm going to hand things back over to Kyle.
Great. Yeah, thank you so much. Just want to say a special thank you to our amazing panelists for your great insights and being so generous with your time today. It was a fantastic and engaging discussion. So on behalf of myself and Marcus Evans, I'd like to just thank you very much for the collaboration. I'm just going to turn things over to the audience quickly. Thank you very much for submitting all the questions. There were so many questions and unfortunately just not enough time to cover it. But I hope you got a lot of value out of this session. And we'll make sure to send you an email after the session to at least address the questions that were asked. And finally, a reminder to look out for an email within the next 2 hours with links to view today's material. And we'd also love to hear your feedback. At the end of the session, a brief survey will pop up, and we'd really appreciate your comments about today's webinar. On behalf of HBL and Marcus Evans, we'd like to thank you all for joining us today, and we do hope to see you again at future events. Thank you very much, everyone. Have a wonderful day further.